Welcome to this lecture, The Rising Threats in Democracy. The Political Science Department has collaborated with Mr. Pace McConkey, the director of the Bell Center for Civil Rights in Education, to present this lecture. It is important that as a community, we educate ourselves on the threats to democracy, here in the United States and abroad. For the past week, we have seen what is happening in Ukraine. And since last January, we have become more aware of the threats to democracy in the United States. It is an honor, it's truly an honor and a privilege to introduce our speaker, the Honorable Robert M. Bell, who was born in Rocky Mount, North Carolina. His parents moved to Baltimore, Maryland, where he attended Dunbar High School. Young Mr. Bell had his first experiences with the judicial system while in high school. At the age of 16, he and a group of other students participated in a sit-in to protest at a segregated restaurant. The group entered Hooper's Restaurant, located at Charles and Fayette Streets in downtown Baltimore, and waited to be served. They were asked to leave, but 12 of the students refused. He and the other students were arrested and convicted in the circuit court in Baltimore City. The crime was criminal trespassing. They were fined $10. The case was appealed in the Maryland Court of Appeals, where the students were represented by Juanita Jackson Mitchell and Thurgood Marshall. The appellants argued that the use of the state's trespassing laws to support segregation of public accommodations violated the 14th Amendment to the United States Constitution. In 1962, the Court of Appeals upheld the decision of the Circuit Court. The case was then appealed in the United States Supreme Court as Bell versus Maryland. The U.S. Supreme Court, noting that the period since the conviction, the Maryland General Assembly had passed a public accommodations law, refused to rule on whether the state's trespassing laws could be used to exclude blacks from public accommodations, but vacated the decision and remanded the case to allow the state court to rule whether the conviction should be reversed due to the change in state law. On April 9, 1965, Bell's conviction was reversed by the State Court of Appeals, and each of the students were cleared of all charges. Ironically, after the Supreme Court's decision, Congress passed the Civil Rights Act of 1964, which banned racial discrimination in public accommodations, such as those provided in Hooper's Baltimore's restaurant. It has been suggested that the Supreme Court refrained from reaching the merits in the case in consideration of this civil rights legislation, which was then pending in Congress, because had it done so, it would have eliminated the basis for passing the 1964 Civil Rights Act. Mr. Bell attended Morgan State College, now Morgan State University, and received a bachelor's in history. He later attended Harvard Law School, where he earned a Juris Doctor in 1969. That same year, he was admitted to the bar and began his legal practice in Baltimore. In 1975, Attorney Bell was appointed to the District Court of Maryland, District 1 in Baltimore City, and served there until 1980. From 1980 to 1984, he was an associate judge in the Baltimore City Circuit Court, 8th Judicial Circuit, until his appointment to the Maryland Court of Special Appeals. 7 years later, Judge Bell was appointed to the state's highest court and became the Chief Justice in 1996. And I should say, the first African-American Chief Justice in the United States. No?
No.
You were not the first?
No.
Oh, I'm sorry.
No.
I was always told you were
The first one in that court.
The first one in that court.
On that court, yes.
I'm corrected. Thank you, sir. 7 years later, Judge Bell served on numerous committees, and in 2006, he was named chair of the National Center for State Courts Board of Directors. He also was appointed president of the Conference of Chief Justices. Needless to say, Judge Bell has received numerous awards, including the Maryland Leadership in Law Award and the Maryland Legal Services Corporation Medal for Access in Justice. Judge Bell is retired. The Robert M. Bell Center for Civil Rights in Education here at Morgan is named after him. He's also a member of the Gilliam College of Liberal Arts Advisory Board. Judge Bell is a member of the Alpha Phi Omega fraternity. Let us welcome the Honorable Judge Robert Bell, Morgan's son, to his alma mater.
Thank you, Dr. Jackson, for that overly generous introduction. May I take this mask off for the moment?
Sure.
I would have worn a K95 mask, but it has those two things on it, so I would have had to messed up my hair to get it off, and I scared the devil out of all of you, so I did the K95, but I really appreciate that introduction. It's a very complete one. And I'm pleased to be here with you today. I thank you for the invitation. I'm just going to take a few moments to discuss with you what I consider to be the most pressing issue of our time, the responsibilities of citizenship, the civic information and engagement, or more accurately, the lack thereof on the part of our citizenry. This is an issue that has been of concern to me for some years now. Context is in order. I've been very fortunate to have been, as you've heard, a part of Maryland's historic court system, with its high court, the Court of Appeals, created by the Maryland Constitution of 1776, being one of the oldest appellate courts in the nation. I was the 23rd Chief Judge of that court, and the first, as you've heard, and only African American to serve as Chief Judge of that court. But as we look back on a presidency that was unexpected, during which countless norms were shattered, including the attempt to prevent the peaceful transfer of presidential power, and we try to cope with the aftermath of a particularly bitter and divisive presidential campaign, and the baseless but corrosive and persistent lie it spawned, we are reminded, as we should be, of the importance of our Constitution, that it should be held in highest esteem. Both the left and the right voice veneration for and urge celebration of the Constitution, and they purport to agree that its charted course is the right and just one. Politicians of all stripes and all political persuasions likewise extol its virtues and wrap themselves in their preferred articles and amendments. So too do citizens. They regularly refer to and insist upon their constitutional rights, often embracing the reference provision by name or designation. We are rightly proud of our Constitution as it stands apart from those of other countries. Not surprisingly, we speak in awestruck terms about the Founding Fathers and the fantastic job they did in drafting such an enduring and effective document, one that has not only endured for more than 200 years, but has been able to adapt to the changing times and challenges without substantially changing our vision or our approach. Yanni Applebaum, a senior editor at The Atlantic, who oversees the politics section of that magazine, agrees with this assessment. In his article, America's Fragile Constitution, which appeared in the October 2015 issue, after referencing the deteriorating condition of the relations between the executive and the Congress, especially with regard to presidential appointments and the funding of the government, he observes, the growing dysfunction of the government seems only to have increased reverence for the document, leading figures on both sides of the aisle routinely to call for a return to constitutional principles. Now, given the last two presidential campaigns and the many issues that they raised that challenge this country's readiness or willingness to continue its commitment to many of the principles long since believed settled by the constitutional language or by interpretation, and their aftermath, we perhaps should reflect upon the Constitution more broadly and consider how far we have come in achieving our more perfect union, and in that way realizing the promise of equality for all, and, as or more important, the role, the responsibilities, not just the rights of the governed. As Chief Judge, I often spoke to lawyers and aspiring lawyers, usually as they were being oriented when they were just starting out. My purpose was, of course, to welcome them to the profession, but also to acquaint them with the nobility of the profession's history, and of course, to encourage them to follow the example set by their predecessors. Thus, I spoke of our democratic republic, the rule of law, the legal profession, and the role of lawyers and judges in its continuation and the maintenance of its quality. Allow me just to summarize briefly what I told them. The foundation of this democratic republic is the rule of law, the most fragile aspect of our system. A critical aspect of the rule of law, that every citizen must receive equal justice under the law, is a concept that separates this society from most others. The rule of law depends for its continued vitality on its chief protector, an independent judiciary, ably and necessarily assisted by its officers, lawyers, especially trial lawyers, the flesh and blood of the law, who since the birth of this republic have stood watchful sentry over the lives, the property, liberty, and freedoms of our people. I informed them that the view of the lawyer as crucial to the continuation of a healthy democratic republic has been recognized by no lesser a personage than William Shakespeare, who in Henry VI had the Cade rioters acknowledge that for their revolution to be successful, it was necessary that, quote, first we kill all the lawyers. I also informed them of the view espoused by the first Chief Judge of the Maryland District Court, of the lawyer as challengers of governmental authority, the protectors against institutional injustice, illegality, and immorality. To be sure, I fully understand that I'm not now addressing lawyers or an audience necessarily of aspiring lawyers. I appreciate that for that reason, you do not deserve or even want a lecture on the role of lawyers and their commitment to our legal system. But on the other hand, over the years, as I have surveyed our political landscape and observed the state of our democracy, I have found myself increasingly frustrated. The year-long controversy over the replacement of Justice Scalia on the Supreme Court is one reason and a recent example as to why. The repeated attempts to repeal and finally to replace the Affordable Care Act, commonly referred to as Obamacare, based only on a campaign promise and without any regard whatsoever to its impact on large numbers of the citizens, represent another. And then there is the election campaign itself, the most recent one, the one where the insurrection at the Capitol occurred, an insurrection which was designed to prevent the transfer of presidential power. And more to the point, and more important, the lie that it spawned, that the defeated candidate had in fact won the election by a landslide. But that is exacerbated by the fact that increasing numbers of the members of one of our major political parties believe that that is the case. And of course, you can all probably think of other examples of what could be frustrating. As a result, I found myself revisiting a choice I made in my youth and returning to the question I was asked so often prior to my retirement. Why did you, a 16-year-old, hoping to become a lawyer, risk your future by getting involved with a sit-in demonstration with its potential for arrest and conviction, and therefore disqualification from being able to pursue your goals? I've always answered that question, aside from not having thought of the consequences at the time, by saying that the Morgan State College student who recruited me and my classmates made the case very persuasively that it was the right thing to do. That, to my mind, is a good answer, and for me, it was a truthful one. But I've always had the nagging feeling that it was neither the only answer nor the best statement of a reason for my actions. A couple of years ago, I was asked by the Community Law in Action group, an organization of youths committed to civic engagement, to speak at one of their leadership and law academies. I told those young people that this society rightly can and should look to them for its last line of defense against constitutional incursions, and I challenged them as citizens interested in the law and civics to give substance to the promise of the founders, to speak truth to power and call out wrongs. Then in October of 2015, I spoke at an event celebrating the United States Constitution. And I took the opportunity to broaden my approach. I advised that audience, consisting primarily of academics and laypersons. I quote, "While not a discrete profession with discrete and discernible rules of conduct in the way that the legal profession is, you qualify as a part of a very special group, the people, the citizenry from whom our democratic republic and all governmental power emanate. Consequently, the citizen is nevertheless as, if not more, important to the sustaining of our democratic republic than the lawyers or the individual holders of governmental positions. In the case of the judiciary, for example, it is true, after all, that lawyers do not, certainly they should not, the causes they advocate create, or courts the cases they decide. They are brought to the attention of lawyers by citizens who believe that they have been mistreated or suffered an unjustified injury. The key point is that it is the trust and the confidence of the people that empower the judiciary, and just as important, determine whether there will be adherence to the rulings it makes. Whether the people have or should have trust and confidence in the government and follow the law is subject to a similar analysis. Critical to the answer is their understanding of their government, its foundational document, and poll star. In that regard, it is important to review what that document, the Constitution, teaches. As we all know, it envisions and therefore establishes three co-equal, and in the sense that no one branch exercises, in addition to its assigned powers, the whole power of any of the other two branches, separate and independent branches of government, two of which are elected by the people. A legislative branch comprising a Congress consisting of a Senate and a House of Representatives, to which is entrusted the legislative authority. Article 1, Section 1, the power to make all laws which shall be necessary and proper for carrying into execution the powers enumerated in Article 1, Section 8, of which the power to tax and spend is one. The executive branch, the executive branch headed by the President, to whom is entrusted the executive power to execute the national laws and who is designated Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States, and a judicial branch comprised of a Supreme Court and such inferior courts as may be established by Congress, in which is vested the judicial power, which, pursuant to Marbury against Madison, includes the power of judicial review, the right to interpret the law. There is, as between these three branches intended to be equal, a real disparity with regard to the allotment of powers. Both the legislative branch and the executive branch have been given real, tangible powers. To enable Congress to discharge its enumerated duties, it has been given the power of the purse, the power to tax. The Constitution entrusted to the executive branch the power of the sword, the coercive power. To the judiciary, there is only a statement of the limits of judicial authority. There's no such grant of a similar or commensurate power. This was understood and indeed was deliberate, as confirmed in Federalist Paper number 78, in which Alexander Hamilton wrote, and I quote, "Whoever attentively considers the different departments of power must perceive that in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the other hand, and contrarily, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. Nevertheless, a judiciary which is strong and independent is a necessary component as a separate, co-equal partner in the system of checks and balances, which is so integral to our system. While in truth, as the Federalist Papers recognized was necessary, none of the branches is entirely separate nor entirely independent. The purpose behind the system of checks and balances is the protection of the citizen against one branch becoming too powerful and guarding against the potential for excesses and abuses of power. This is achieved by each pursuing its constitutional mission, asserting as and when required its constitutional independence. The intended result is a dynamic tension between our branches from which discord and conflict may flow as a natural consequence. An understanding of these relationships is a prerequisite to an active and meaningful participation in the governing process. That was recognized and anticipated by the Founding Fathers, as demonstrated by an encounter between a Mrs. Powell of Philadelphia and Benjamin Franklin as he left the Constitutional Convention. "Well, doctor, what have we got, a republic or a monarchy?" she asked. With no hesitation, Franklin responded, "A republic, if you can keep it." The Founding Fathers settled on a republic rather than a direct democracy because they believed that form of government would best protect the people's natural rights as outlined in the Declaration of Independence, because it recognized the right of the people, which it reserved to them, to establish good government from reflection and choice rather than by accident and force. As explained in Federalist Paper number 10, Unlike a direct democracy, a large republic with many competing interests would make it less likely that one faction or interest would be able to maintain a permanent advantage. Although individuals with similar interests form coalitions or partnerships, the founders believed that coalition politics would become a practical necessity and that coalition building would promote moderate politics. Likewise, the Constitution provided a means, the separation of powers again, to protect against individuals who might abuse the position to which he or she was elected, and consequently the public trust. This works, however, only if citizens educate themselves on important policy issues so as to be informed voters. Also required is that the citizens vote and engage in civil discourse at all levels and have, at a minimum, courage and boldness, independence and self-reliance, prudence and self-restraint, and reasonableness and civic knowledge. Without an understanding of their government, its departments and functions, diligent citizens cannot know whether governmental actions are properly taken and what issues they may raise or how best to address them. Such awareness, on the other hand, while engaged in keeping informed politically and civically, will help the people better appreciate the issues and the significance of historic, political, cultural events. Indeed, the civic engagement of the people is essential to the health, vitality, and continuation of our democracy. So I amend my answer to add, it is the necessary thing to do. We, today's voters, are heir to we the people, whose representatives gave us the Constitution, whose provisions we regularly invoke. In fact, we now are we the people. As a result, our responsibility is not only to ensure continuation of our foundational document, but also to ensure the faithful adherence to its various mandates, to keep it special, to give substance to its promises. This is especially the case when the public's confidence in the three branches is at or near all-time lows, and with the advent of the internet and the proliferation of ideology-based media, print, voice, and visual, one person's fact or reality may be construed by another person as fake or alternative. It is to these voters, the ordinary citizens as much as lawyers fighting the legal battles based on the Constitution, that this society rightly can and should look for its last line of defense. Thus, it falls to them and their peers the task, and there has to be a commitment, of becoming and remaining informed and engaged in grappling with the many difficult and complex issues of today. Most important, those concerning the constitutional rights, the acceptance and inclusion of their fellow citizens, making sure that they are confronted directly and with dispatch and on a principled basis and addressed. In that way, the Constitution is honored, and more to the point, the voters accept and exercise the responsibilities of citizenship. Sadly, in these ideologically divisive times, there are too many voters that simply do not measure up to that standard required to ensure a healthy, working democracy. Too many accept and exercise the engagement prong of their responsibility, willingly participating in the electoral process by voting, attending rallies, campaigning in all of its various forms, but neglect or fail to do the hard work of being or keeping informed. While these voters may diligently consult their preferred source of news, rather than critically assessing their pronouncements, including their source, they just accept them. And they do so even when they are illogical, inconsistent with reputable, unbiased, and non-ideological sources, or, most damning, the exact opposite of what they themselves observed or experienced. In short, the identification of the problem does not solve the problem. It is just a start of a critically important, but sure to be contentious conversation. But it is a conversation that must be had. It is not an answer to blame the politicians for misleading their constituents, as was the approach when Hillary Clinton criticized Trump voters as deplorables. The voters must answer for their own failures. They should not be allowed to escape scrutiny or responsibility for failing to meet the standard democracy requires and therefore demands. The foregoing is not the only possible problem. That analysis, my analysis I've just given you, presupposes that all of the parties agree that a working, viable democracy is the goal. There is, however, evidence that a sizable portion of one of the major parties is anti-democratic, that they want, if a democracy at all, one that is drastically different from that to which our democratic republic has evolved. Legislative actions in a number of states, which the Republican leadership has endorsed, indicate that they want to limit who can vote, which will be accomplished by restricting how voters can vote, where they may vote, and the identification required to vote. This, too, is a necessary conversation to be had, albeit the premise and the nature will differ. And of course, I've not exhausted the number of problems that may exist. Put together, they all are threats to our democracy. And the one I first described is the biggest, the most imminent, the one that has the most potential to choke off, in fact, kill our democratic republic. And ladies and gentlemen, that's my story, and I'm sticking with it.
Well, thank you so much.
Well, I hope you all
Judge
understand. Yeah.
You gave us a good lesson on the Constitution, and I have to tell you something.
What?
Some of the students in the audience are in one of my classes, and I'm giving an exam next week on American government.
Is that right?
And so if they took copious notes, they would remember the structure and function
Yeah.
and the different branches of the government. So
Yeah.
thank you very much.
Yeah.
Would you like to, are there any questions from the audience?
I'm ready.
Okay, please identify yourself and ask your question.
Yeah, my name is Anthony Chandler. I'm one of the students here at Morgan. I'm a history major.
Mm-hmm.
You alluded to it, but you didn't mention directly that I think white supremacy, which has taken over our government, is one of the biggest threats
Yeah.
to our democracy.
Mm-hmm.
The Republican Party has wholesale embraced this white supremacist ideology. How do we fight back and deal with that?
By voting. No, I did allude to it by pointing out that they accept things wholesale. The real reason that many of the Republicans, and we may as well call them Republicans, many of them accept, and the Republican voters accept whatever you tell them, which permits them to vote Republican, is because they are fearful of a shift in the population over time, and it's more imminent now than it has been in the past. And so they're more willing to accept any and everything that will permit them to take an action or vote without having to run the risk of being called a racist. And by the same token, they have now become more comfortable even with that. When Trump became president, he, like Reagan did before him, gave them permission to say some things that were never said before. It would have been taboo to say before. And so white supremacy undergirds this fear that is driving so much of what causes the the red states for the most part to vote the way they do. They're afraid of the shift to the point where they become minorities and will then be subject to being treated as minorities, the way they treated minorities before. And so there is no doubt that white supremacy is not is at the bottom of this. It's right. It lurks it lurks in the background, but it is now coming to the fore. You saw in the news, I guess, the other day that Marjorie Greene, the congressman, appeared at the white supremacy convention, but she's not alone. A number of them do. Trump has winked and nodded to them throughout the 4 years that he was president, and he continues to do so as he looks forward to the next run. So no, I'm very much aware of it. But what the point I really want to make, though, is we've got to hold people accountable for how they vote. And we have to call them out when their vote is inconsistent with any logical interpretation of the facts or the information on which they're basing the vote. What struck me back when Trump was running was the reaction, not only of the politicians, which you should be able to expect their reaction, but of the media. When Hillary Clinton called out the voters for being deplorable because they were not interested in anything other than the misinformation that they were being fed, she caught more criticism than you could shake a stick at. And it wasn't the first time. When Barack Obama talked about the Republicans having their guns and their prayers, he caught the same flack. And what happened? Rather than hold those people responsible or accountable for their actions and for the consequences of what they were doing, Barack Obama had to apologize for having called them out. Hillary Clinton had to apologize for having called them deplorables. The media jumped all over it. It was a big deal. That was for her and for him, it was a gaffe. It was an error that they'd made in their campaigns. It shouldn't have been, because our democracy is based upon a premise, and that premise is that the people who are governed and who are also the governors will have enough knowledge of what's going on, what the issues are, as to be able to make considered judgments. And if you don't have that, then the democracy is in trouble. It cannot operate. That's what Benjamin Franklin meant when he said, a republic, if you can keep it. The voters have to make considered choices in voting people in. You can't make a considered choice if you don't know what you're doing, if you don't take the time to investigate those people, true, but also what the issues are and how they all interrelate, so that the people you put into place will provide, as the Federalist Papers tried to explain, will provide good government by choice and on the basis of reason and reflection, as opposed to by accident.
Any other questions?
Yes, sir.
Who do you want?
Right here, yeah.
Oh, Dr. Baluku.
My name is Zek Botakuba. I am an associate professor of philosophy at Morgan, and I usually tend to avoid going to many crowds, but I came because I know who was going to speak. So thank you very much for being back to your alma mater, Lawrence University. I am originally from the Democratic Republic of Congo.
All right. Mm-hmm.
I came to this country
Mhm.
in the possibility of a better working
Right.
democracy in this country. And more specifically, the election and the re-election of Obama made me believe that
Mhm.
I can belong
Mhm.
to a country that finally is accepting some of the rules of democracy.
Right.
I spent 2020 thinking and even writing and voting. I wrote a book in 2020 dealing with some issues you raised,
Mhm.
democracy in this country.
Right.
With the victory of Joe Biden and Kamala Harris, I drank some champagne because I thought
Mhm.
my reflections and some of the things that I wanted to happen happened
Mhm.
until we saw January 6th and what happened thereafter.
Mhm.
To the question, what do we do with white supremacy, which was your question, you gave a good answer by saying vote.
Mhm.
Now the problem is, if you vote and your vote does not count, that's a problem. And we know that the Trump big lie has led not only to January 6th insurrection, but also to a series of Jim Crow 2.2,
Mhm.
2.0 laws that are going to make it difficult to make many people's vote count, and that's what we are facing. And I wonder what your wisdom
Well, you know,
say about all this.
I don't have any. I really don't. I mean, I'm about where everybody else is, except that I have an abiding faith in the fact that there are more people who believe in democracy than do not. And what we've got to do is to make sure that those people understand the danger that we're in and that they vote. And that they do what they did in 2020. That is, go to the poll under adverse circumstances, any circumstances. Don't take no for an answer. Don't take any obstruction being placed in your place as a deterrent. And that's the only way we're going to be able to do it. The good people, the people who are who are thinking logically and thinking appropriately with regard to our constitutional system, are the ones whose burden it is to carry that ball across the finish line. That's the way I see it. I don't know how you can do it otherwise, because our system, the unfortunate thing is, our system is a good system so long as you've got people who are ethical and who are all interested in the same thing, that is the continuation of the democracy. If you've got people who are interested in the continuation of the democratic society, then you'll have them working together. Unfortunately, we have seen over the last 8 years, 12 years, because what gave rise to Trump was Obama. Had it not been for Obama being elected, we would never have gotten Trump. So unfortunately, you know, the good, you got to take the good with the bad. You got to take the bad with the good. So what we've got to, so when Obama, when Trump was in, he started changing the dynamic, and he started, as I said, he gave the green light to the white supremacists and those who are on the fringes, who are not quite white supremacists, who are afraid of what the future holds. He gave them the green light to push back. We have now got to give the green light to those people who do want to see the right thing done to push back as they did in 2020. And if we don't get them to do it, if we're not successful in getting them to do it in this next upcoming election, I'm afraid that we may very well lose the democracy that we've had for more than 200 years. Yeah.
Oh, we'll take you, Robin. And what can I
think it
just?
was somebody over
Oh.
there.
Yes, good afternoon. Thank you, Judge Bell,
Mhm.
And my question is related to the last question, and it's quite simple. I just would like to know, does the president have the power to sign an executive order to protect voters' rights?
No. No. Uh, You need and that's the problem. The Congress is necessary to pass the laws. And if the Congress can't function, then the president can take actions around the edges, but he cannot take the critical action that's necessary to protect the right vote. Remember now, the Voting Rights Act of '64 came through the Congress. And that's why they were so anxious to put into place, or put back into place, legislation that would have reinstated the Voting Rights Act. It didn't happen. And the president can't change that. So in order to get that done, we're going to have to put into place a majority in the Congress sufficient to pass the law. Now, it's easy in the House of Representatives because you only need a majority. But in the Senate, that's an anti-democratic body because the Senate requires a supermajority vote to pass anything other than those exceptions which were made by the body itself. You know, judges, the cabinet members, certain legislation which relates to the budget. Other than that, it takes 60 votes to get anything through. So in order for us, unless we're willing, the Democrats are willing, to change the rules, you're going to need to get enough senators to reach that 60-vote threshold. We failed to do it this time, and we failed to be able to convince enough Democrats to change the rules. So we're in a situation now where it's up to, and I hate to do it, but you come right back to the need to vote, to put into place people who will do what needs to be done. And, you know, what we've got here in the Senate, quite frankly, is a situation where the minority rules. Minority rules. It's a majority. We're supposed to be, democracy is based upon a majority view, but protection to the minority. What the Senate has done in recent years is to flip it on its head. It now becomes a body which protects, which is ruled by the minority with no protections for the majority.
Okay, is there a question over there, a student? No, Professor Skate?
Thanks again, Dr. Bell, for being here. My question is this: so as you sat in at that counter in the '60s,
Mm-hmm.
and we fast forward to your concern, what you stated was the #1 problem.
Mhm.
Do you see some similarities? Because I know in my classes, we've listened to various speeches from that time period that you sat in on the counter.
Mm-hmm.
And we can close our eyes and ignore the person speaking, and that language could be spoken to death.
Mhm.
As far as rights being taken away, the black-white conversation, and also voters' right issues, and a number of things that we seem like we're moving backward instead of forward.
Well, you're right. There are issues that you thought were settled. They're not, because with the change in demographics, you start seeing a pushback from the majority demographic, and what was acceptable yesterday becomes unacceptable today because it's a threat to the new majority. And so, no, I don't dispute at all the fact that we are relitigating and we're reliving, not in the same way. I mean, it is less onerous, although in the case of voting, it may be worse this time around, because if you've got a situation where the guy who counts the votes is a partisan and is able to do whatever he wants with regard to determining what the vote count is, that's worse than it's ever been. But we've never been in a position where we had the ability to get the majority in the first place. So we are moving back. A lot of the issues that I thought were settled are no longer settled. We have to relitigate them. And we have to do it, unfortunately, under a climate and in a situation where the climate is not quite so positive for us as it was back then, because the court in the 60s, even you go back to 1890, you go back to 54, the courts were much more sympathetic to, well, I shouldn't even say that. The courts were much more inclined to apply the law. Now you have the ideological gloss being put on it, so that the fact of the matter is that we are in more peril now than we would have been before, because there is on the court judges who specifically have an ideological bent. You know it, and they're in the majority. So no, yeah, I appreciate your point. We're in the case of we're not trespass so much, but we're in a position now where voting has been returned. We've been returned to a past condition that I thought we had passed before. Although I guess when I think about the religious freedom issue is being used to deny rights as well, and so that reminds you of an earlier time when things seemed to have been better. But you know what you need to come to, I guess we ought to all come to grips with this. I just recently came to grips with it. I've always talked about whether I was pessimistic or optimistic about this or that. I have now come to grips with it, and I realize that I'm never, whatever your view is, you're not being either pessimistic or optimistic, because the America has always been what America is. And all you do is accept the reality of what's there.
Any other questions? You, sir?
Hello, my name is Jalen Pringle. I'm an elementary education major and a poli-sci minor. My question, I have a little preface for it though. So in the 2020 presidential election, 66.8% of citizens ages 18 and older who are eligible to vote voted. And in the 2016 federal elections in Australia, 91.9% of eligible citizens turned out to vote. So I know you made the point that, voting is essentially kind of like the core of what people need to do to affect change in their country and in their communities. But how do people who are interested in seeing that change take place, and people who are politically engaged, or at least care about, who is elected, how do they combat voter apathy in people who are not necessarily as interested, or who may be interested, but feel as if the people who represent them, or the people who may represent them, don't care about their interests?
Well, if I had the answer to that, I'd be in good shape. The only thing I can tell you is that we have got to continue trying to push the envelope as much as we can, meeting people where they are, making the case to them, and hoping that what our efforts are enough. We did a pretty good job in 2020 because we got, in a lot of places, record turnout. We've got to continue along those lines. There's no silver bullet. There is no way that anybody that I know of who would come up with that can convince somebody to vote. You've got to be in their face, go where they are, you've got to make the case, you've got to cajole, you've got to beg, you've got to do all kinds of things to get people to understand it's in their interest to vote. I can't explain it because we got a democracy that is the envy of the world, so at least it used to be, and yet we've always had low voter turnout. We've never had high voter turnout like in other countries where they value the vote more than we do. I don't have the answer. You just gotta keep pushing it, going where they are, being an organizer, being an apologist maybe. You gotta do whatever you need to do to get people to understand the value of voting, particularly now, where the democracy itself is at stake.
So,
Mm-hmm.
Judge Bell, on that line, and I know you say you don't have the answer, but just to be very specific, because we're at a historically black college, that, our turnout, black people of color turnout is extreme. We're the lowest as far as the turnout. What have you seen over your time dealing with people that calls for that, especially when in this day and time, and maybe always, we're the ones that have the most to lose. So
Well,
if that's not motivation enough, then
in the old days, it was because we didn't have faith in the system and didn't believe it was going to benefit us one way or the other. And now that we've seen the value of it, I don't have an answer for why we won't do it. But I do know this, we will never be able to increase the turnout if we don't individually and collectively make that effort on a continual basis, not just at election time, but make that make that part of your daily discussions. Don't wait until elections, but have that as an apple a day keeps the doctor away. That kind of thing has to be a part of the whole conversation each and every day.
Any other questions? I have a question.
Yeah.
Is there any other question from the audience? Okay, so my question, Judge Bell, is democracy is really being threatened.
Mhm.
Last night there was a race in Texas. Yesterday there was a race in Texas. And there were 30 seats
Right.
that Trump had endorsed 30 people at the local level, and they all won the election.
Mm-hmm. Yeah.
And I'm saying to myself, oh my, what's going on here?
That's the primary.
Right, but that's
Let
the most
us-
important,
you-
the most important election at the local level.
Not necessarily. Not necessarily. It depends upon, sometimes you get people who are radical.
Mm-hmm.
And these people that Trump has endorsed, or have endorsed, these folk are radical. And if you get the right person running against them, you have a shot. You may not win all of them.
With 30? Yeah,
Yeah,
that was
Yeah.
scary.
I know, but this is in Texas, right?
Yeah,
This is in Texas, and Texas is a deep red state. But you still have to take a shot at these folks.
yeah, that's right.
And when you start talking about, there may be a chance if you are able to get those folk who are sitting it out to come out and vote. Because I still say there are more people in Texas who do not agree with
What's going on?
Trump than agree with him. And if you can get those people to come out, you have a shot at winning. The problem is that we can't get them to come out.
So I have another follow-up question. When you demonstrated,
Mhm.
when you and your students came and demonstrated at Hooper's, you were all motivated to make a change, to
Mhm.
end segregation.
Mhm.
What can we do to motivate our students today to do things like that?
You know, what we miss about this is that was a student-led demonstration.
Protest, uh-huh.
You know, I was a high school student.
Mhm.
Had the Morgan State students not recruited us, I would never been involved in anything. But the students themselves were the ones who started the protest. They kept it up for more than 10 years before the A&T people
You're right.
who got the credit.
We're
So
first.
Morgan's been at the cutting edge all the time. It is something that, you know, you see something that's unjust. Young people have the ability sometimes to pick up that ball and run with it. That's what happened here. And I suspect nobody motivated them to do it. Somebody felt a need to do it. And I suspect that you've got young people who have it within themselves to start a movement. But the thing that we need to keep before them is the successful movements that have occurred. We've got to make sure that we do not downplay, but
What happened?
we uplift those young people who were at the cutting edge and who did begin protests and sit-ins to desegregate institutions, not just at Morgan, but throughout the city, which then moved to other cities and other states, and which resulted in this shopping center, which excluded black folk for so many years, becoming all of a sudden pretty much a part of Morgan. It is, students have got to be made aware of what has happened. And hopefully there will be something, some spark that will be picked up and they'll run with it.
Thank you so much. Are there any other questions for the Honorable Judge Bell?
Can I ask one?
Sure. Mr. Kennedy.
Thank you. I want to ask you this question because of your experience as a judge. You indicated initially in your remarks the essential characteristic of the rule of law
Mhm.
in order to preserve democracy.
Mhm.
And I thought of two instances, especially with respect to the judiciary's role,
Mhm.
two instances right now where lower courts have declared unconstitutional practices put in place by two states.
Mhm.
One in Alabama,
Right.
where the redistricting process
Right.
resulted in an election district that discriminated against African American voters.
Mhm.
And the other in Texas, where the lower courts ruled that the Texas new law on abortion,
Right.
women's right to choose, were held unconstitutional. In both of those instances, the United States Supreme Court has allowed those clearly unconstitutional practices to remain in place pending its review. In Alabama, it means a discriminatory election law will be in place for this election
Sure. Mhm.
process.
Mhm.
And in Texas,
Mhm.
women are being denied
Mhm.
what the Supreme Court has clearly held to be a constitutional
Right.
right,
Right. Mhm.
to the point that Justice Sotomayor,
Right.
in a dissenting opinion, wondered if the court would survive the stench
That's right.
that this creates
That's right.
with respect to
That's right.
abortion rights.
Right.
So, am I to be concerned, are we to be concerned if the rule of law seems to be at risk, even at the hands of the highest court in the land.
Of
Or
course.
are we not there yet?
Of course, because, you know, the courts depend for its power, for its legitimacy, on the trust and the confidence of the people. And if the people start seeing the courts as illegitimate, as not doing what it's supposed to do, then the people will withdraw their power, their trust and their confidence, and the standing of the court will deteriorate. And that's one of the reasons I suspect that John Roberts, in the most recent case, sided with the liberals, because he's trying to save the legacy of the court. So yeah, we ought to be terribly concerned if the courts are not going to apply the law as it should. Then we really don't have a rule of law. What we have is an ad hoc decision-making, and ad hoc decision-making is antithetical to the rule of law, antithetical to democracy, because there has to be a certain amount of predictability so that people can order their behavior and their actions on a daily basis when they're dealing with matters, whatever they might be, issues that go before courts, etc. So, yeah, we ought to be concerned, and we ought to be concerned about that right now, because if you look at the standing of the court, it has never been as low as it is right now. The Supreme Court, I mean. Never has been. It's falling down into the range where the Congress and the President is, and that's not good. So yeah, we have to be concerned about it. But then that's the other problem with the democracy, though. Whoever's in charge, in power, gets to appoint the judges. And if you allow them to do so in an ideological way, then you are in effect putting the whole democracy at risk, because to the extent that they act ideologically, and the people and voters recognize that that's the case, then they will have less confidence, less faith in not only the judiciary, but in the entire system. They're all interrelated. Particularly since if you look at what's happening now, people are looking at the courts as merely an extension of the political process. They don't see the courts as that body that sits there and looks low and makes decisions based on the law. They see it as a group of Republicans or a group of Democrats making decisions consistent with the attitude, the views of the party which elected them.
Okay. Are there any other questions of Judge Bell? Dr. Butakuma,
Somebody
over there?
expressed some concern about the lower participation of minorities, especially black, in our democratic system. And of course, that is a right concern. However, we want to applaud and commend, for example, the voters of South Carolina who revived the political comeback of Joe Biden. I don't think that
Right.
In the US, things sometimes don't go well because there are too many lawyers. And so your comment about that. And also, if you could comment about the nomination of the black
Ketanji Jackson.
Oh, yeah.
Jackson, not the one who is there. But
Well, I'm very pleased with that. I was very disturbed when, with the reaction, when he said he was going to name a black woman.
Yeah.
The reaction was as if a black woman could not be the best. And the truth of the matter is, if you look at her resume, and you look at her body of work, I can't imagine that there are many people out there who would be any better than she is. And it's about time, quite frankly, that we did have someone who looked like me, but wears a skirt on the court. So I'm very pleased for it. But of course, I was not surprised at the reaction when he said he was going to name a black woman. I was not surprised. They did that before anybody was named. It was just knee-jerk reaction. If you say I'm going to put a black woman on the court, then I'm going to criticize you for discriminating. Notwithstanding the fact that Trump said, I will only put somebody on the court who will overturn Roe against Wade. Now, you're talking about limiting the number of people who could sit on the court. That's a limitation right there. It's a lot more stringent limitation than saying I'm going to put a black woman on the court. And yet nobody really paid as much attention to that as I thought they should have. Of course, I'm also concerned at the fact that we don't do as well in terms of our vetting through the confirmation process, these folks. I would have said when each one of those people were brought to the fore, I would have raised the issue about their willingness to overturn Roe against Wade, but I would have done it by asking them whether they felt any need to make a statement disavowing that position. Because if you say to me, I'm only going to appoint somebody who's going to overturn Roe against Wade, my position, if it's me, that I'm going to be put on that court, my inclination is to say, no, I don't buy that.
Yeah.
And if you don't react that way, it seems to me, that disqualifies you as far as I'm concerned. But anyway, no, I'm very pleased with this woman. I would have been happy with any one of the three. Although, and I must be honest with you, if I'd had my druthers, it would not have been any one of those three. It would have been Sherilyn Ifill. It would have been Sherilyn Ifill.
Oh, yeah.
That's who my choice would have been.
Yeah, her name.
But she had no chance because of the work that she's done and how tenacious she has been in pursuing equal justice for everybody.
Yeah.
Mhm.
Any other questions, any other comments? Well, Judge Bell, you are a wealth of knowledge and information. And
Well, I don't
we
know.
are just so honored. Thank you